Yes.
My lords.
Listed mention 801.
I'm sorry.
Lordship, the tentative date is shown 19th. Request is not to be related, please. Not to be.
I have a question that I have recently reached the stage of the Bihar. We want to file a counter affidavit to guide 2 weeks may be given. Well, let's say, well, let's the matter is coming to final adjudication and notice was.
Let us.
At least final.
File it. Permit it.
That's 802 is a regular bail matter.
Huh?
There is no tentative date being shown, my lords. I'm only asking for a fixed date, my lords, in the month of January.
What is the urgency?
It's a regular bail matter, my lords. I've already undergone 1 year, 6 months of
What
custody.
is the offense?
My lords, offence are under good state talk, my lords.
Huh?
Provisions under good state talk, my lords. There is a medical condition of the petitioner, my lords. He had undergone a heart surgery, my lords, recently.
Wiki 12.
Grateful.
My lord's leave, my lord. Your lordship had permitted us at item 42 that house eviction of. My lord recollects that the Delhi Airport Authority chairman is in the house and they said it's farmhouse, whether it's farmhouse, not farmhouse. My lord gave me the liberty to mention it because I'd asked for a fixed time. Your lordship said when it's on board, mention it. I know, my lord. Today I understand, but is it possible in the afternoon at least, my lord, after the part?
Well, it's
After that bail matter.
this is not that kind of a quick matter. 5 Act also may have it properly on a NMD or something on January. Because
No,
this
my lord,
requires 5
they
Act.
got a stay, of course they want January.
What
Even
else?
their case was,
Next
my lord, their whole case was that they had a right to renew. Even that renewal was over in March 20.
Minus the
I don't
clause,
know where it's
it's a landlord tenant
I
matter.
know the merits
You
now.
should document the file.
So
How
1
many
month.
senior counsels appearing for how many parties?
They are for the desperate parties.
We are the ones who are desperate.
There are more than one?
Yes.
One party.
That number is in inverse proportion to the merits of their case.
Huh?
That number is in inverse proportion to the merits of their case.
More
I
than
don't
one.
think so. Otherwise they wouldn't be the appellant. They would be the respondent.
Lighter way.
To outweigh you, they'll have to wait more, little more.
Yes, yes.
Okay, tell us what. Today it may not be possible because we are.
Tomorrow, my lord, it's impossible, my lord. Tomorrow, if your lordship.
No.
Then, my lord, next week, if your lordship would have it on.
Next week is a miscellaneous day, Mr. Aravind.
My lord, after your lordship's miscellaneous board.
We have listed 3 matters. Monday, Tuesday, and Wednesday. But exclusively for that 2 parted. You know that hearing the crash of 1987.
Would your lordship, then I only have one request. January, if your lordship would give us a fixed time.
Yes, yes, we'll have it some 2 o'clock or
Please,
something.
please,
Very
my
great.
lord.
Very
January, either the first or
Tell us.
second week.
First week again.
Second week.
Second week,
of
second
January,
week.
2 o'clock.
15th, 20th, whatever suits my lord.
You tell us.
20th, 30th, you want.
No,
The second week.
Second week, 15th, I'm saying, sir. Second week is 15th.
13th, I think, my lord, is second week.
You're getting hyper about
Commences from 12th. So we'll have it on 13th.
13th, my lord.
13th January, Tuesday.
At 2 o'clock, if your lordship would.
Go.
I'm obliged.
Go.
Lordship, please.
Great.
My lord, kind permission, my lord, in item 39, the petitioner circulated a letter. He is traveling to his hometown for his own marriage. So he's asked for accommodation of 1 week.
13, what is that?
Now, this is the better way, my lord. My lord had asked us to file a compliance affidavit, which we have filed. The administrator, my lord, the modern.
The lordship says that interim order, the lordship says till next date. So that's
Interim order extended. Mentioning that. What is item number?
They have filed the letter.
One second. 42. 42. Singhvi and Aravind. Yes, sir. 39 is it?
39, my lord. They have filed, the petitioner has filed the letter, circulated letter.
Who is appearing for the letter is there?
Yes, let us there.
All right.
They asked for 1 week, my lord, next week anytime.
Not next week. Item matter. Second or third week of January.
Fix it.
It will come. They are looking to the diary in there.
Grateful, much of that.
Lord's leave me, Lord. Item 45 on your lordship's board, your lordship said to remind you at 10:30.
What is that?
That is that land matter where they have suppressed from an entire litigation and the status quo is operating against me for the last 3 years. That where that they have to give the delay, explain the delay of 15 years.
All right.
So,
We'll see after the preliminary work is over, then bail matter is first involved.
or in sometime, Your Lordship.
We'll see, come at 12:30.
12:30, I'm applying. I'll inform the other side also.
All right. Item 1.
May I please, my lords? Lords, I'm seeking a short accommodation. My lord. So, any next step, my lords?
At request of the petitioner council, this is first week of March. Item 2. You said there is some extra to the 3 lakhs. 5 minutes. There's some fresh matter, bail matter.
10 minutes.
All
I can finish and come back.
All right.
I'm obliged.
Ask someone to hold the fort.
That's, I'll be here, but 10 minutes.
All right. Item 3. No, not yet. This is for fresh bail matters.
These are also 2 matters. 3 and 4 also bail matters.
Yeah. Yes.
My lord's, item number 3 is the bail matter. It's coming after notice. The state has also filed the counter affidavit. My lords have issued notice in the month of September. And my lords, this is a case which arises of the counter clause that the girl of the petition number 1 here, Mathura, was molested. Thereafter, this FIR was lodged by the one who has.
Item 3, no?
My lords, item 3.
How many, what is the period of sentence you are completing?
My lords, 1 year, as of today, it's more 1 year, 5 months as of today.
Look at the injuries, sir. You are already convicted.
My lords, I beg them, my lords, there is no specific allegation. The one
What
who
specifically?
believe
You are the one who molested.
is the Virendra Chauhan.
Main assailant, Your Lordship. He's the main assailant.
He should not argue his case.
I'm sorry, I'm sorry.
Otherwise, we'll do what the respondent, any advocate objects or interrupts. We'll ask the other side also to interrupt in your argument.
I'm really sorry.
This attitude has to stop. You will get your chance, argue your case, we'll hear you. No.
Yes, my lords, may I submit? My lords, the allegation is that Mathura Sharma, Congress Sharma, hold of the Virendra Chauhan, and Dilip Sharma, who has polio from his legs, right leg, has inflicted multiple injuries, my lords. Thereafter, the person who was injured open his eyes in the hospital, then goes to the police station for lodging of FIR and holds the knife to the police officer. After lodging of the FIR, the knife was himself given to the police officer by him. And accordingly, the FIR was lodged. The role of
Who is it?
Pilots,
302 or 307?
307. Pilots, the injuries is said to have been inflicted on the chest, but the medical report, if my lords may see at page 43. The doctor himself says that this can be a self-inflicted injuries. This is not a sharp injury. This is not a grave injury, and this can be considered self-inflicted.
Where is it?
My lords, at page 41. My lords, para 16. It's a part of trial court's judgment. May I read, my lords? Prosecution witness 6, Satyadev Chaube, who is a medical officer, stated in his evidence that on 3/6/12 he was posted at Singhvi Primary Health Center. On the day he examined Virendra Chauhan, age 30, at 9:30 a.m. and found the following injuries: sharp cut injuries 2/1, 6/1 at the left side of the chest. Semi-lunar wound area about 2 in the diameter on the extreme lateral of midline. Age of injury within 6 hours. Type of injury sharp cut simple. Simple caused by hard and blunt substances. And thereafter, after 2 paras, may I read the complete. The witness presented has identified the injury report as being in his own handwriting and signature. The witness presented during the cross-examination has stated in para 4 that the color is not an essential fact to determine the age of the injury. In para 5, he has stated that he has not written whether he found any change in the color or not. In para 6, he has stated that if someone can take such a risk, then such an injury can be created.
For the purpose of hoisting a false case, anybody would take that risk.
My lords, because this is a case which is arising from the counterblast where the Mathura Sharma's daughter was molested by Meeran Chauhan, who is now being examined by the doctor. And the annexure P1 at page 21 is the complaint of the daughter regarding the molestation which has happened the night before.
All of them are seeking bail, is it?
My lords,
All the 3 are seeking.
all the 3 are seeking bail, my lords.
So it is Dilip Sharma who stabbed.
Dilip Sharma is the person who is
victim and Mathura Sharma.
Dilip Sharma has the main role. My lords have
And Congress Sharma.
Mathura Sharma is the father of Dilip Sharma and Congress Sharma is Dilip Sharma's uncle. They're the family.
Dilip Sharma caught hold.
Dilip Sharma, Mathura Sharma and Congress Sharma caught hold. Dilip Sharma inflicted injury. Whereas my lords, on the first date, my lords was not inclined to issue notice to Mathura Sharma and Congress Sharma. Dilip Sharma
Because he was physically challenged.
he was physically challenged and has tumor in his legs.
Huh?
My lords, in the counter affidavit which was filed by the state at para 14 of that,
1 second.
the state has confirmed
Paragraph
14,
which
page 4 of counter affidavit filed by the state. May I read, my lords? My lords, the state states, it is stated that the medical officer, Central Jail, Buxar, medical condition of the 3 convicts were called, and on 5/12/2025, it has been reported that convict Dilip Sharma is suffering from ankylosis of bilateral sacroiliac joint with significant straightening of humor and thyroid curvature of spine. My lords, he has undergone surgery of his spine, my lords, because
it
of
has also been reported that he is hemodynamically stable.
my lords.
Jail hospital is there, they will take care.
My lords, that is the issue. My lords. He has a tumor, my lords, and he is unable to, my lords. That's my instruction. I'm stating on the instruction that he's facing too much of difficulty there. When he has undergone surgery, he needs good care, my
When the
lords.
surgery was undergone long back.
My lords, he is suffering from the same because this is not non-curable, my lords. This is
Then that means he is living with that. If a person with so much of disability was able to
my lords. This is
cause the stab injury,
made up case, my lords.
or which accused will admit that it is not a made up case.
My lords,
Everyone will say.
my submission because this is made up case.
After full-fledged trial, you have been found to be guilty, sir.
My lords, if I take my lord to the statements of PWN, he says that I witnessed the incident, and then thereafter he says that I reached the spot after 10 minutes. And
There is
then
any change in the medical condition of the petitioner. This, what is his name? Dilip Sharma.
my lord, it is
Then you
deteriorating.
can move the jurisdictional right. That liberty you can. That's all. If there is any change in the medical condition.
My lord, the situation is such that his health is deteriorating.
If it deteriorates, then it is not deteriorating. The doctors say that he has been reported that he is hemodynamically stable.
My lord, that better to that, my lords, but this is a condition which cannot be cured, and he is
Yes.
My lords, and this is regarding Dilip Sharma, and the other two has no role then holding.
You have already rejected them.
My lords on the first date has rejected, but my lords may see para 15 of the counter affidavit at page 5. Mathura Sharma has gone blind, my lords, and he is aging 69, my lords. This is the case where all three needs due consideration of my lords. And at page 5, para 15. And he has
heard the learned counsel appearing for the parties. We are not inclined to entertain this petition, even in respect of Gulfisha Fatima. Full stop. At the time of issuing of notice, we noted on 18/9/2025, his court took note of the fact that he was physically challenged and suffering from polio. Full stop. In order to ascertain the factual matrix, notice was ordered and the counter filed by the state will disclose that he is stable and reported that he is hemodynamically stable as per the doctor's certificate, annexure R1 dated 5/12/2020. Hence, reserving liberty to Mr. Dilip Sharma to revive his prayer in the event of there being any change in the medical condition by approaching the jurisdictional high court for grant of bail, this petition stands dismissed. The prayer for grant of bail, having in respect of other two petitioners, having already been rejected, stands upon.
My lords, may add one thing at this stage. My lords may I can revise my prayer after a few months, my lords. Because these are very senior citizens.
You want to say after 50% of the. Anyway, you keep opening, let it be an open window, you just take your time. Next. Item 4. Yes.
What is the well-reasoned order by the petitioners were included in the suit was set aside by the impugn order. If your lordship may kindly see page.
Who is that person who has been impeded?
What is the petitioners?
Huh?
Petitioners.
What is your right?
But it's the petitioners are in possession. That's what I've.
How did you get into possession?
I'm in possession since last 50 years. My father's.
How? By virtue of what? How did you get to property?
Your lordship may kindly see page number.
Please tell us, sir. How did you acquire title to this property?
Well, it's
gift, sale.
Well, it's your lordship may kindly see. I am
Illegal possession.
But I am in possession, and that has been.
You tell us, and what is the nature of your? How did you acquire your possession? Someone said you occupy this land.
No.
How? What is?
It was in my possession of my father since last.
How did he get it? It could not have come from somewhere up above this time, right? Either by inheritance or by prescription of title by adverse possession, or illegal occupation, or trespass, or purchase, or mortgage, whatever. Tell us, how did you acquire the title?
It's a suit regarding that is already pending.
Then, how are you basing your claim for the property?
That is not mentioned here, but if your lordship should see page 57 for a minute, my lords.
What are the dependents relating? How are they related to?
One of the defendant is a real brother.
Real brother.
My lords. That's page 57, para 17.
Suit for?
My lords, it is a suit for declaration and seeking perpetual.
Filed by your brother?
No, my lords, he is the respondent number 1.
Who has filed the suit?
Respondent number 1 has filed the suit.
Who is the respondent number 1? How
He
is
is the original plaintiff, my lords.
How is he claiming title to the property?
He is claiming title through sale deeds. That
Executed by?
Executed. There is a different many sale deeds
Executed by whom?
But the last sale deed, as per his statement,
You have filed a suit?
Or I haven't filed, but there is another suit which was filed by my father that is already pending before the district court. But meanwhile, this respondent number 1 has filed a suit and sought injunction against the defendants. But my claim is that I am in possession of this property, which was accepted by the trial court.
Notice. Notice.
It's the trial.
Second week of February.
The trial is proceeding.
Let it go. We will not stay the trial. The state of Maharashtra, Odisha.
Maharashtra.
Huh?
Maharashtra.
As it is, civil suits are getting 30 years, 40 years. Let the suit go on. It is of the year 2000.
It's 2022.
Let it go on.
Obliged.
Item 46.
The learned senior advocate is appearing through virtual mode. 46 minutes, your lordships had asked us to file a complaint in this minute. I did just yesterday.
Yes.
Mike not on record. The counsel for the petition is appearing through virtual mode.
Yes.
May it please lordships. My lord, this is a case where the incident took place on 16th of May. And I am a lady incarcerated since 17th of May, my lords. And the total allegation is that my son called him for some compromise, which is the detail whereof is not available at all with the prosecution. If my son called him, my lord, they came to abduct my daughter, and as of retaliation, my lord, self-defense of my life of my daughter, my lord, at 11:50 p.m. Now, my lord, this incident took place as per the prosecution story. And my lord, the total allegation against me is that I caught hold of the deceased, who was a young boy of 22 years. And my husband caught hold of the deceased, another deceased who was 22 years. And my son stabbed one. My husband, holding the deceased, stabbed him. This is the, my lord, improbable story. An old lady, I'm a lady of 62 years.
What is your role according to the prosecution?
According to the prosecution, my role is, my lord, that I got hold of one deceased, whom my son stabbed. This is the total allegation. My lord, an old lady of 62 years, I'm a primary school teacher. Entire family has been roped in. Entire family has been roped in, my lords. My husband, my daughter, my son, everyone.
Mr. Senior Counsel, 62 is not old.
Definitely. Yes. Looking to my lord. Yesterday, in fact, last evening, my lord, last evening I shared my lord's photographs.
To yourself.
My lord, last evening I shared my lord's photographs with my friends. And I said, tell me how old my lord is. They said he doesn't look more than 50 years.
Thank you for your left-handed.
My lord, I wanted to be physically present, but because of there was a difference in the board. In fact, I was informed that it will be taken up after lunch. And I had to rush from Mumbai to Delhi, my lords. So I was on my way from the airport. Because of this Indigo crisis, my lord, there's a lot of problems. So I say, my lord, this old lady, I call her old, my lord, because the lady...
Get that counter. Is it available?
So I say, my lord, that we don't have to get carried away by the fact that it is a double murder case. My lord, the role of the lady, as has been attributed, says that I caught hold of a young boy of 22 years.
You want to just pass it over and just get copies.
Physical file. Physical file. Get that count.
We just get physical copies.
Pass over.
Pass over.
Obliged, my lord.
Item 47. Lordship, I'm seeking pass over. I'm seeking pass.
It will be passed over for the week. Choice is yours.
AOR is on his legs, my lords.
So there is no urgency in this matter.
No, there is urgency, but he is.
Pass over. Don't call this matter till 4 o'clock.
Item 40.
Lordship, this SLP arises from rejection of anticipatory bail application.
Give the physical file. 48.
48. 48.
Yes.
Your Lordship, this complaint case has been filed under section 200 CRPC, but I have been only summoned for section 498A in this case, and there is no FIR has been lodged, and there is no this complaint has been filed by the wife.
Then why are you summoned? In which case you are apprehending arrest? Complaint case 757.
Amit Kumar versus state of
Huh?
Amit Kumar versus
Yes.
the state of
In which case you are being summoned?
It's a complaint case which has been filed by the wife.
You are appearing for.
Your Lordship, I'm appearing on advance service for the state. Your Lordship, it's a complaint case, so we have a limited rule in this.
Who is appearing for the second response? Notice is not.
Notice has not been issued.
Issue notice. This will be an interim protection from any coercive steps being taken against the petitioner.
Much obliged.
Until further orders.
49.
49.
I am for the petition, item number 49. The Lordship will request for a accommodation as the council is not available due to his personal difficulty.
Request of petitioner council list in second week of February.
Item 2.
In 2.3, I just wanted to disclose one factor that which Mr. Sibal argued. The petitioner has moved the learned special judge, the trial court, for interim bail pending this SLP, yesterday for his own sister's wedding. It has been granted in the past also, but only for interim. I just
serial number
2.3. I just
what is the name of the
Umar Khalid.
Umar Khalid.
But he had in the past also moved such applications which were allowed for short interim periods. His real sister's wedding. I didn't want to not mention it to the court. I'm obliged.
I'm in 2.1.
Volume 1 and 2, Lordship.
That's 2.1. Because I
You are some of the Sharjeel Imam.
yes, ma'am. Because on the last occasion, my lords, I had submitted before your lordships about that FIR 22 of 2020, which is registered, my lords, in January of 2020. In which I was taken into custody, my lords. Now, this January, I will complete 6 years in custody, my lords. Whichever way your lordships are to look at the matter, my lords, on the merits of it or otherwise of the merits, my lords, on pure custody period.
Who is on the other side?
Mr. Raju said he is in Bombay last time, my lord, so he will some.
I am here for the state, my lords. My colleagues are there in the court too, my lords.
All.
Please, my lords.
So whichever way your lordships are pleased to have a look at the matter, my lords, on the merits or otherwise of it. 6 years, my lords, I'm one of the persons who have been in custody for the longest period of time. Not participated, no role in the actual riots. Persons who are actually involved in the riots, my lords, or even in conspiracy to commit riots, who are physically present in Delhi, they have been enlarged on bail. So, my lords, on the grounds of custody period, on the grounds of parity, my lords, and on the ground of the fact that my speeches, for which much of the labor has been done by the state, is being tried in a separate offense altogether. Not offense, separate cases altogether, not case, my lords, separate cases. But there's one important fact, my lords, your lordships may just bear in mind. The act that the prosecution alleges falls foul of section 15 of UAPA, my lords. According to them, it's my speech. According to me, my lords, and my respectful submission, what has to fall within section 15 is the conspiracy to commit the riot. That is the charge against me today, my lords. Charge is not whether my speech individually is falling foul of section 15, my lords. This I am arguing because of the condition under 43 I have to show on a prima facie basis, my lords, about the non-application of the section under UAP. That part of UAP, my lords, 15, which leads to the conspiracy, which is the conspiracy, is to commit the riots. Both the conspiracy to commit riots and the riots, my lords, has to be under section 15. Now, in the actual riots cases, 750 FIRs, my lords, section 15 is not invoked. Not invoked by them, my lords, in the actual. Now, this is a peculiar FIR, my lords, and your lordship's experience will bear to this, that conspiracy to commit an offense is being tried separately from the main offense itself. 750 FIRs, my lords, for the offense, which is actually committed pursuant to the conspiracy. And this is conspiracy, my lords, to commit that offense in which I am not named in any of those 750 FIRs. It is like, my lords, murder and conspiracy to commit murder, or conspiracy leading to murder. Murder is being tried separately, my lords, and conspiracy to commit murder is being tried separately. I could understand that no act came into effect after the conspiracy. If there is an act, my lords, then necessarily the two should have been tried together. So what we have to see, my lords, is, in my respectful submission, that my speech is conspiratorial in nature. That conspiracy is section 15. If that goes out, my lords, with my respectful submission, then 15 will not apply, my lord. Then there are other sections. One additional fact in my favor, my lords, is that in the trial for the speech, or in the prosecution for the speech, I have been enlarged on bail. So the speeches by themselves, I have been.
That is which FIR?
Yes, that's FIR, my lords, 2020. It's 2020, FIR 22 of 2020. Just one second. In which I was in custody for 4.5 years. And I wanted to show, my lords, your lordships, my lords, not only that's in Delhi. For the same speech, I'm prosecuted in Uttar Pradesh, where the speech happened, which is Aligarh. The Allahabad High Court also enlarged me on bail in the Aligarh speech. Now, please have a look, my lords, just for a moment, at the order which granted me bail.
In FIR number, the Aligarh?
That Aligarh FIR, my lords, is 55 of 2020. This is not mine. Mine is a marked one. You're giving me a new one. Because I had given a chart like this, my lords, to your lordships. I know there are a lot of papers. I'm sorry for that. There are a lot of papers of this nature. Every one of us on our side has handed over this. This had all the FIRs that are registered.
1 to 8.
1 to 8. Yes, on the other side, my lords. Yes, 1 to 8. So that indicates, my lords, the status that is there. If your lordships are pleased to have a look at serial number 4, my lords. At serial number 5, sorry, 4 is Manipur, 5 is the UP FIR, as we've titled it, 55. It is registered on 25th of February. It's registered on 25th of January. But sorry, please make a correction. It's 25th of January. Yes, I have it wrong. It's 25th of January. So about the same time as FIR number 22
Not
of
25th February.
No, it's not February. No, sorry. It's 25th January.
Oh.
Now just please have a look at the bail order. In the paper book itself, my lords, at page 167, this is the High Court order.
Yes.
It was 167.
167 of what?
Of the paper book. In 2.1. This is the High Court order. After noting down at page 168, my lord, that there are other FIRs that have been registered against me for giving the speech, at paragraph 5 of that, my lords, at page 169. .1 of the paper book.
2.1.
Sharjeel Imam.
Yes.
SLP paper book. SLP itself. Page 167.
Something else. 167.
Because it's annexure P4. Yeah. P4.
Yes.
Now please see 169. 168 sets out a table of all my prosecutions for giving the speeches, and 5, paragraph 5, my lords.
Having
heard learned counsel for the parties and having perused the record without referring to the exact allegations made against the applicant, it may be noted that on undisputed basis, neither the applicant called anyone to bear arms nor any violence was incited as a result of the speech delivered by the applicant. The exact imputations made and the effect prompted by the applicant by words uttered or gestures made therein, etc., may remain to be examined at the trial which is yet to commence. Inasmuch as the applicant has remained confined for more than 1 year and 2 months against the maximum punishment that he may suffer on conviction, being 3 years for that reason alone, the applicant has become entitled to bail at this stage. Therefore, paragraph 7, my lords, therefore, the said issue also falls outside the scope of the present proceeding. In any case, the speech having been inside the state of UP and the FIR having been registered with respect to the occurrence at Aligarh, no fundamental jurisdictional defect is shown at the registration of the instant case. This is against me. Last, as to the criminal history of the applicant, the same may remain to be considered in appropriate case. However, at the pretext, considering the period of detention undergone in the context of the fact allegation made, the same may not deprive the applicant on bail. So where I gave the speech, where the FIR is registered, I am enlarged on bail. Delhi combines all of this, as I indicated to your lordship, is the mother FIR of all the speeches because there are different speeches. That is how it takes place, my lords. Now, please also consider, my lords, the order which dismissed my bail in FIR 22 of 2020 by the trial court. There's some finding there, my lords, that your lordships will find at page 298 of this annexure P5, my lords. P5 is P5. No. It's annexure P8, my lords. And I'm reading this. This is when the trial court dismissed my bail. There are certain observations that are made in it for the narration of the facts at page 299. Your lordships may have a look at page. It starts at annexure P8 starts at 291. At 299.
Paragraph 20.
23 minutes.
20 is also relevant.
20, I'll read 20 minutes. As far as the first order titled, as Sharjeel Imam versus State of UP is concerned, although the same relates to the similar kind of offences, but the case regarding those offences was registered at Aligarh, I'm obliged, and the case in hand was registered at Delhi, and the facts herein are quite different. As far as the two other judgments are, now comes 22 laws, now comes for consideration the facts of the present case for considering the relief to the applicant. In the charge sheet, the allegation against the applicant are that in the context of CA NRC, the applicant delivered different speeches, a speech at Jamia on 13/12/2019, at AMU on 16/1/2020, at Asansol on 22/1/2020, and at Chakband on 23/1/2020, thereby inciting public, which ultimately triggered the communal riots in different parts of Delhi. It is noted that the incidents or riots triggered on 13, now this is talking about a December riots, 13/12/2019 at Jamia, on 15/12/2019 at New Friends, and on 16/12/2019 at Dayalpur, on 17/12/2019 at Silampur, and Jafrabad on 20/12/2019 at Simapuri on Nagri. The contents of speeches clearly show that the applicant incited the public to do chakka jam and block the cities, particularly in the speech of 16/1/2020 as delivered at AMU. The applicant said that if a particular number of people are organized in the northeast part of the country, can be permanently or temporarily cut. The applicant in the speech dated 22/1/2020 at Asansol said that the members of the particular community are not in police, army, court, and the parliament, which was totally wrong and misconceived. Besides this, the applicant spoke about a number of things and facts which may not be true, thereby provoked the public as gathered at different places. Further, the voice samples of the applicants were sent to CFSL, and the report confirmed his voice in the mentioned speeches. Not only the applicant gave inciting speech, but he created a WhatsApp group, Muslim students of JNU, to raise voice against CAA and NRC, and was active in it. Further, the applicant drafted, prepared, and distributed pamphlets containing such material so as to instigate the members of a particular community in order to mobilize them against CARC. And this material was recovered from the desktop. It is noted that the charge sheet after the speeches of the applicant, and due to his activities, a number of protesters and protest sites in Delhi increased, and as suggested by the applicant, the crowd started blocking the main road, which consequently put the whole city on standstill. Finally, just after the speeches, the alleged activities of the applicant on different dates and places, the riots occurred, causing violence, huge damage. Now, 25. It is noted that although the applicant did not ask anybody to pick weapons, and kill the people, but his speeches and activities mobilized the public, which disrupted the city and might be the main reason in outbreak of riots. Further, through inflammatory speeches and social media, the applicant skillfully manipulated the real facts and incited the public in order to create havoc. Further, the words as used by the applicant in his different speeches were so powerful that they captured the mind of the people of a particular community and incited them to take part in the disruptive activity. Although the court cannot take into consideration section 124 IPC, but in the facts of the actions of the applicants are considered in normal dictionary meaning can be termed as seditious. Thus, keeping in view the alleged acts of the applicant, the court is of the view that the facts in the case are not normal and different than the facts been. Considering the allegations against applicant and disrupting others, courts deem it fit to know. So this was the ground why it was denied to. After holding that there was no call for anybody to pick up any weapons or kill any persons. And the material is there at page 299, which is the prosecution for the speeches that have already taken place, pursuant to which the riots took place at 299. So, my lords, I am being prosecuted not twice, not thrice, but maybe penta or hexa, not double jeopardy, my lords, but hexa or maybe about 8 times or 10 times for the speeches that I have given. In the speeches, in all, I am in bail or default bail, and this is conspiracy to commit riots, my lords. At the then, my lords, comes the next page, if your lordship just maintains this paper book itself. This is it was 302. Your lordships have till 299. Please see 302. Is when bail is granted. At para 23, the High Court is pleased to notice that the learned trial court got swayed by the enormity of the allegation, observing that he made inflammatory speeches, which resulted in the bail was declined. And thereafter, the High Court proceeds, my lords, to grant bail at para 26. That there was nothing that would disentitle the accused from seeking relief under section 436A CRPC. So in the table, in the chart table, my lords, your lordships will find for the speeches, I am no longer in custody except for the present matter. Now, my lords, there's just one order more that your lordships would see. No, there's no order. I finished the orders. No, I'm not sure. Now, there is something I have to show, my lords, at page 103. Since much has been said about my inciting people, etc., is the Facebook post in the counter affidavit that has been filed by the respondents. If your lordships are pleased to have the counter affidavit, that's the common counter affidavit at page 103. Lordships have the common counter affidavit on behalf of respondents of NC. You have a blow up of what this is. Well, it's at 103, sorry.
It's Sharjeel Imam under the tutelage of top conspirator.
Yes. Tutelage of, now, Sharjeel Imam under the tutelage of top conspirators Umar Khalid conspired to escalate the scale of riots. Conspiracy physically manifested itself in the second phase of Delhi riots. This could be established on the following. Now, please see this Facebook post, though it's not readable as far as what is produced, but maybe my Lord Justice Aravind Kumar is on digital mode, so it can be zoomed probably. For my Lord Justice Anjaria, my lords, I can hand it over in a slightly more zoomed form, my lords, where it will be readable, my lords. Yes.
आंदोलन को दूसरा चरण में ले जा रहे हैं.
I'll make an effort to read it.
Why you don't?
Fluency is
As good as mine. Okay. The same boat, don't worry.
I'm bilingual just to speak, but to reading it, man.
We can read.
My learned friend can read it more fluently.
Gujarati, I know we can read.
My Lord Justice.
They're all same. Sanskrit words.
If I may.
Yes, yes.
हम लोगों ने आज शाहीन बाग रोड के चक्का जाम को
हम लोगों ने
I'm reading from the first line, Lord.
Okay.
In the what is said in the post.
Right. हम लोगों ने आज शाहीन बाग रोड के चक्का जाम को राजनीतिक पार्टियों के गुंडों द्वारा हिंसा की आशंका और आंदोलन के राजनीतिकरण से बचने के लिए वापस ले लिया है. हमें आशंका थी कि पुलिस को बीच में ना लाकर भाजपा स्वयं आंदोलनकारियों के साथ हिंसा करना चाहती थी. यदि ऐसा होता है तो अहिंसात्मक आंदोलन पर न केवल दाग लग जाएगा बल्कि लोगों का मनोबल भी टूट जाएगा. इन 20 दिनों में हमने बहुत कुछ हासिल किया है, जिसमें महिलाओं का भाग लेना और आंदोलन का अहिंसात्मक रहना महत्वपूर्ण है. हम इस रोड को कुछ दिन बाद दोबारा जाम कर सकते हैं यदि हम शांतिपूर्वक हट जाएं. हमारे सैकड़ों स्वयंसेवी और महिलाएं जो रोड को जाम कर रहे हुए थे वो वहीं सो रहे थे और उसी आंदोलन को उस स्थान से हट गए हैं. अब हम सबसे अपील करते हैं कि अभी तक जो भी मदद आंदोलन को पहुंचाई जा रही थी जो बंद कर दी जाए, क्योंकि इसको राजनीतिक पार्टियों ने हाईजैक कर लिया है और वहां पैसे के लालची लोग बैठे हैं जिनको ना दंगे से ना समुदाय के अच्छे या बुरे से कोई फर्क पड़ता है. हम आंदोलन को दूसरे चरण में ले जा रहे हैं और हमारी कोशिश हांगकांग के तर्ज पे फ्लैश मॉब करने की और अन्य शहरों में फैलाने की है. कृपया इसे अधिक से अधिक साझा करें.
So it's a call for non-violence. That if it turns violent, not participating, please don't make a non-violent protest into violence. It is being hijacked by political parties. That is what he says. And this is the material that is placed in the counter affidavit before your lordships, my lords, to show that this is conspiratorial in nature. Please see 103. This is what it is. And I leave Delhi. I'm not in Delhi. From then till January, till when I'm arrested from hometown in Bihar. I'm not here. I'm not member of.
What is that speech of 16/1/2020 of Sharjeel Imam?
That is Aligarh.
What is it?
That is Aligarh, my lords. In Aligarh, in that extracts of speeches that the state handed over.
Same counter.
Same counter, my lords.
See. Below. 104.
Speech, yeah, all right. At AL. The speech of Sharjeel Imam establishes the fact that he was threatening unity, integrity, and sovereignty of India by exhorting Muslim population to dismember. The relevant extract of the speech is this is Friday night.
तो हल्का फुल्का वायलेंस हुआ था. मेरा भी चश्मा.
Read it loudly, no?
Can you please read that? Friday night.
Friday night को तो हल्का फुल्का वायलेंस हुआ था. मेरा भी चश्मा टूटा था. लेकिन हमें दिल्ली बंद इसलिए करना है कि आवाम को इनकन्वीनियंस हो. ये मैं पहले भी शायद अर्ज कर चुका हूं कि 5 आवाम इज पॉपुलेशन पब्लिक जनरल पब्लिक
जस्ट पब्लिक.
ये मैं पहले भी शायद अर्ज कर चुका हूं कि 5 लोग हमारे पास हों ऑर्गेनाइज तो हम हिंदुस्तान और नॉर्थ ईस्ट को परमानेंटली कट कर सकते हैं. असम को काटना हमारी जिम्मेदारी है और असम और इंडिया कटकर अलग हो जाए तभी ये हमारी बात सुनेंगे. अगर हम असम की मदद करनी है तो हमें असम का रास्ता बंद करना होगा फौज के लिए और जितने भी लोग जहां से भी सप्लाई जा रही है उन्हें बंद करो. वो बंद कर सकते हैं क्योंकि चिकन नेक मुसलमानों का वो इलाका वो मुसलमान अक्सरियत है.
So for this speech, Allahabad High Court grants me bail. For this speech, it is not that order is challenged subsequently. For this speech, my lords, it shows just this speech doesn't show that I'm talking about in Delhi there will be riots. My lords, that's why I'm laboring, my lords, to say for the speeches.
Which are given.
Yes, my lords.
You are not given the dates of that speech. No, item number 3, speech given by petitioner Aligarh Muslim. What date?
Yes. I have another. I can revise this chart and I will include the date, my lords, and I will give to your lordship. Can you make another chart? We'll do that, my lords. The dates when the speeches and the FIRs when they were registered, when I was taken into custody, little more elaborate. That's why, my lords, I'm laboring and repeating, which is something that I don't like to do, my lords, is that please eschew the speeches from consideration. And I had addressed your lordships, my lords, on the last occasion, that something more.
16.1 is AMU speech.
16.1 is AMU. 13.12 is Jamia. It's there in my SLP, my lords, if your lordships are pleased to have that. Otherwise, I'll give a chart also to that effect. At page R.
Aligarh Muslim speech is dated
16.1.2020.
Aligarh?
16.1.2020.
Aligarh also.
Aligarh is 16.1.2020.
There are 2 speeches of 2 FIRs of Aligarh.
There are 5 FIRs for Aligarh. Same speech. Same.
So one registered by Assam, one by Manipur.
Yes.
And another by UP.
And one by Delhi. Please.
The Arunachal Pradesh is also 16.1.
So Assam seems to be the major one, my lords. Aligarh seems to be the major one. Aligarh has, my lords, the present, the FIR 20 of 22 of 2020, plus one in as number 3 in Assam, Aligarh in Manipur, in Aligarh in Uttar Pradesh, at Arunachal Pradesh, and Delhi. So many prosecutions for one speech. By a reasoned order of Allahabad High Court granting me bail for that speech, my lords, an order of the Delhi High Court granting me speech. That's after 4.5 years. 4.5 years, my lords, I got bail for the speeches. For the speeches FIR, that's the mother FIR. And now conspiracy for riots. Because I had argued before your lordships, my lords, and respectfully submitted. Speech by... Lords.
Can you please come to page number 105
of the counter?
Those 2 speeches also.
105?
Yes.
In the counter.
Imam, Sharjeel Imam has
on 20, on 22. Asansol. Yes. Should we read that, Manu?
Yes.
पिछले 6 महीनों में जो हुआ है वो किसी और कौम पर डायरेक्ट हमला नहीं है, वो मुसलमानों पर डायरेक्ट हमला है। पिछले 6 महीनों में जो हो रहा है वो मुसलमानों पर डायरेक्ट हमला है, ये याद रखिएगा। सीए इसकी अगली कड़ी है। जब हम सड़कों पर निकले हैं तो हमारी सारी परेशानियों का हिसाब लेंगे। जब हमारी कौम सड़कों पर आई है तो वो हिसाब लेगी सरकार से।
Because this is in the backdrop of what is he giving the speech about? There is a legislation that is introduced in Parliament. He is resisting that legislation. It is not that there is one fine day he wakes up and some terrorist attack is committed. It is that there is a legislation. He's entitled to protest against the legislation. Some of his speeches, words used are unpalatable. I don't stand here and reason it. I'm not justifying whether it could have been better worded. He could have not said a lot of things. He could have remained within the 4 corners of law, confined himself to 4 corners of law. That is my, I'm frankly submitting, my lords, regardless of the instructions as a counsel, my lords, I'm saying unpalatable. Shouldn't do it, should not have done it, has done it today, my lords. And today, my lords, he is standing before your lordships, asking for bail that after almost 6 years in custody, your lordships may kindly consider that he be released on bail, particularly when he is not physically present and not an accused in any of those cases of where the actual riots took place, and already in custody almost a month before when those riots took place. So therefore, my lords, respectfully, I was submitting to your lordships, speech, conspiratorial may not come, my lords, because conspiracy involves a meeting of minds and agreement between two people. Who is he doing with? I don't know, my lords, according to the prosecution. He is going everywhere and giving his speeches. There is no talk. I am not member of that DGSP, that WhatsApp group, which they have labored upon and said this is the WhatsApp group.
Come to the speech of 23/1/2020.
The one below that.
Yes.
Chakan. 106
I read it.
Yes.
हमने हाईवे जाम किया है, हमने पेट्रोल पंप को सूना किया है, टोल टैक्स खत्म करवाया है, हमने शोरूम बंद करवाए और नोएडा I'm so sorry. हमने शोरूम बंद करवाए और नोएडा का हर मुलाजिम अपने घर 4 घंटे देरी से पहुंच रहा है 2 बजे रात को। ये हमारी कामयाबी है कि हमने दिल्ली में 1.5 महीने से ट्रैफिक जाम किया है, ये हमारी कामयाबी है। अरे भाई, बिहार में जजुडिशियल कैंप बनेगा तो क्या कीजिएगा, जाके जलाइएगा ना उसको। हमको सड़क जाम करनी है और हमको हर हाईवे बंद करना है। केवल 4 हफ्ते हैं, सोच लीजिए 4 हफ्ते में आप क्या क्या कर सकते हैं। 4 हफ्ते, लड़कों की कमी नहीं है, ये बात समझिए।
Plus 4 hafte is because the matter came to this court under challenge.
No, that means he is admitting in this speech, an earlier speech.
Yes, my lords.
Of 22/1.
Yes, my lords.
Can you please read once again?
पिछले 6 महीनों
पिछले 6 महीनों में जो हुआ है वो किसी और कौम पर डायरेक्ट हमला नहीं है, वो मुसलमान पर डायरेक्ट हमला है। पिछले 6 महीनों में जो हो रहा है वो मुसलमानों पर डायरेक्ट हमला है, ये याद रखिएगा। ये इसकी अगली कड़ी है। जब हम सड़कों पर निकले हैं तो हम सारी परेशानियों का हिसाब लेंगे। जब हमारी कौम सड़कों पर आई है तो वो हिसाब लेगी सरकार से।
These are excerpts, lords. Can I play something for my speeches which abhors violence, says no? Now these are only excerpts.
These speeches also you have given it.
I have given them, prosecuted for them, and granted bail for giving these speeches. Now today they want, my lords, the state wants, your lordships, that I should be prosecuted.
In 23/1/2020 speech, you admit the above speech, that is the speech of 22/1.
Yes.
And you also admit that resulted in Chakka Jam and engineering riots.
No riots, my lords. It's only Chakka Jam. बैठना, हम बैठे।
In the area of Jamia.
Your Lordship is reading 104, Lord, page number 104.
Friday night को
हल्का फुल्का violence हुआ था, मेरा भी चश्मा टूटा।
That means just some pushing and shoving was there. There were no violence.
Serial number 1 of the chart.
I know. Now, if that chart your lordships are pleased to have, please see the first FIR of that. FIR 296.
Violence at Jamia University.
So for everything I'm already prosecuted, my lords, for everything, for some violence, for some speeches, for everything I'm already prosecuted in custody. Now the state wants to argue, my lords, that my speeches are conspiratorial in nature, and I've submitted to your lordship, my lord. It can't be conspiratorial in nature. There's one additional fact, my lord. The state has labored much about how my speeches are so egregious that they have threatened the sovereignty and integrity of India, my lords. And Section 15 is invoked. Because the premier investigating agency of UAPA offences is the National Investigating Agency, NIA. They have a right of first refusal over investigating any cases of UAPA. If your lordships were to take up the NIA Act, under Section 6, it is the mandatory duty of a police officer registering an FIR of a scheduled offence. There are about 8 scheduled offences. UAP is the only one which is of some bearing. Other is atomic energy, etc., which offences are generally not called. A police officer registering an offence under UAPA mandatorily is required to give that information to the state government. State government passes that information to the central government. Central government then decides, depending on the gravity of offence, gravity of offense and other relevant factors, whether NIA should investigate or not. 2 points, my lords. Neither for my prosecution under section 13 of UAPA, which is the section, that's the 22 of 2020 FIR, where section 13 is invoked, which in my respectful submission is the only section that is applicable for the speeches, where I'm talking about the disintegration as far as India is concerned. NIA is not handed over. I'm not aware whether this procedure was followed, but I'm taking it was followed. And NIA. You get copy NIA, copy something. Copies. You open it online. Well, may I just pass on one copy, if your lordships, while it is coming. There's one more, Lords, I'll just.
No.
Now, please see section 6 of this one. And NIA can investigate only the scheduled offences, no other. Now, investigation of scheduled offences, the Lordships has section 6, Lords. May I just show the schedule first? If your Lordships has a look, there are only about 8 enactments. 8 in the sense, the rest are of the IPC. In 8, there is one schedule only, as defined under section 2(1)F, my lords. It has explosive substance, atomic energy, and UAPA, anti-hijacking, suppression of unlawful act. So offences, my lords, which really threaten the sovereignty and integrity of India have been entrusted, the investigation of those offences have been entrusted to the NIA to investigate, not the local police. What does the local police do, my lords? Their jurisdiction is not ousted. But the right of first refusal, my lords, is of the NIA. Please have section 6. That on receipt of information and recording thereof, under section 154 of the code relating to any scheduled offence, the officer in charge of the police station shall forward the report to the state government forthwith. So that means the moment there is a FIR registered regarding a scheduled offence, he has to forward it to state government. On receipt of the report under subsection 1, state government shall forward the report to the central government as expeditiously as possible. Now, 3, my lords. On receipt of report from the state government, the central government shall determine on the basis of information made available by the state government or received from other sources within 15 days from the date of receipt of the report, whether, now first one, my lords, whether the offence is a scheduled offence or not, and also whether having regard to the gravity of the offence and other relevant factors, it is a fit case to be investigated by the agency. Now, the 4 is 5 is even more important, my lords. 5 is, notwithstanding anything contained in this section, if the central government is of the opinion that a scheduled offence has been committed which is required to be investigated under this act, it may suo motu direct the agency to investigate the offence. So when the blast happened near Red Fort, NIA moved in to investigate. All those cases are there. Singularly absent. Much is being said by the state now. This is very bad. This is very egregious. You are threatening the sovereignty, integrity of India. No entrustment to the NIA. No decision by the central government to say that this is a grave offence, my lords, that requires investigation by the NIA. Now, my lords, at the end, my lords, I'm only praying, my lords, that your lordship, one is that parity part that I have, that the parity, there are persons who participated Unlike my counsels on my side, I'm not throwing anyone under the bus, but I'm only saying those who participated in riots, those who were physically present, those who were part of the WhatsApp chat group, those persons, my lords, have been granted bail. Those who have been part of the meeting, I was not physically part of the meeting. Only speeches and speeches alone as far as the material against me. And I'm again expressing.
What was the speech given in the Maligar Muslim University on 16th January?
That is that same speech, my lords. Chicken neck and Assam. Chicken neck, cut off chicken neck. Assam will be isolated.
Since it is in Hindi, we require your assistance. Can you please come to page number 116, 115, and 16.
This is Aligarh.
16-1 speech is little bit objectionable.
Yes, it is objectionable. I don't stand to.
That is your speech.
That is my speech.
Can you please read that Hindi portion?
At 115, you know,
Yes.
starting.
Yes. Slowly.
Yes.
Oh,
Right.
I have to understand.
Right. I'll be sure.
But my lords, I'm certainly reading it. But I'm going to show the good parts also.
Also, we'll see.
Yes.
इसके पहले तो मैं यहाँ दिसंबर 10-11 को भी आया था और उसके बाद मैंने उस दिन भी यही बात रखी थी.
We'll do one thing. We'll hear the good thing first.
The good news before bad news. Play. Well, there was negative. Not working. So it's not coming here. It's not coming here.
याद रखिएगा, कॉन्स्टिट्यूशनलिटी का मतलब हम प्रॉपर्टी नहीं जलाएंगे, मामला है, हमें पूरा इस्तेमाल करना है। कॉन्स्टिट्यूशनलिटी का जहाँ तक मामला है वो तो हम है, कॉन्स्टिट्यूशनलिटी अलग चीज है, कॉन्स्टिट्यूशन अलग चीज है। याद रखिएगा, कॉन्स्टिट्यूशनलिटी का मतलब हम प्रॉपर्टी नहीं जलाएंगे, ठीक है, हम लोगों को नहीं मारेंगे, ठीक है, अरे भाई हम डिसरप्ट तो कर सकते हैं। बिल्कुल बिल्कुल।
There is no way to get out of it. अगर कॉन्स्टिट्यूशन ही हमारा सहारा है, कॉन्स्टिट्यूशनलिटी की बातें अलग है। जैसे मतलब एक पॉलिटिकल लीडर है जो कॉन्स्टिट्यूशनलिटी की बातें करता है कि हमें प्रॉपर्टी डैमेज नहीं करना है, हमें सेल्फ डिफेंस के अलावा किसी पर हमला नहीं करना है, किसी पर हथियार नहीं उठाना है। ये बातें हुई कि कॉन्स्टिट्यूशनल डिबेट्स जो चल रही है हमारे वक्त, व्हाट इज द कॉन्स्टिट्यूशनल वे या कॉन्स्टिट्यूशनल स्पिरिट की बात की जा सकती है एक हद तक। हम लोगों ने दूसरे दिन ही शाहीन बाग में कैमरे लगवा दिए, मतलब रोड के किनारे आगे तक, तो पुलिस आए तो जो हो कैमरे के सामने ऐसा ना हो कि रात के अंधेरे में मार के निकल जाएंगे। जो हो कैमरे के सामने हो और फिर ये उठाया लाठी, हम भी देखेंगे, दुनिया देखेगी ये क्या कर रहे हैं। तो ये औरत आपने जानिए में नदीरे का वीडियो देखा होगा, तो वो एक लड़के को शाहीन को जो मार रहे और दो लड़कियां जो है घेर करके उसको बचाने की कोशिश कर रही है। तो वीडियो देखा होगा आपने, है ना? आप उस वीडियो में देखिए, कैमरा चल रहा है तो पुलिस वालों की हिम्मत तो ये हो रही है कि लाठी मतलब मार पाए, वो इधर उधर से घुसाने की कोशिश कर रहे हैं कि लड़के को मार पाए, क्योंकि उनको पता है एक लाठी पड़ते ही केस तो पुलिस को बनेगा ना। पहले हम कैमरे की मौजूदगी में काम करें, हम कोई बुरा काम कर नहीं रहे कि हमें कैमरे से करना है, हम तो अपने हक के लिए लड़ रहे हैं, तो कैमरे लगे रहेंगे। 100 शाहीन बाग कैसे बनेंगे जब आप हिम्मत वाले 100 जवान लड़के पहली सब पे बैठे होंगे कि आओ हमको मारो, आओ मारो, जितने मारना मारो, हम यहाँ से हिलने वाले नहीं है। समझिए इस बात को, हमें पत्थर नहीं उठाना, हमें लाठी नहीं उठाना, हमको गोली नहीं चलानी, हमको करना क्या है, हमको सड़क जाम करना है और हमको हर हाईवे बंद करना है। यार मेरी गुजारिश है ऑर्गेनाइज ऐसे हुई है कि पार्टी से मतलब नहीं है, चुनाव से मतलब नहीं है, ना हम वोट मांगने आए हैं, ना हम पैसे मांगने आए हैं, हम बस आपकी मदद मांगने आए हैं कि देखो भाई लड़ना अपने लिए, जब अपने लिए लड़ना है तो मुत्तहिद होकर के, ऑर्गेनाइज होकर के, भाई 100-200 तो जाबाज लड़के हम मार खाने वाले, मारने वाले नहीं, मार खाने वाले तैयार कर सकते हैं, जो मार खाने को तैयार है, हम है तो। बिहार में न चल रहा है, बिहार अकेला सूबा है जहाँ अल्हम्दुलिल्लाह जहानाबाद वाले छोड़ करके दंगे नहीं हुए थे। 30-40 साल से हम कम से कम इस इलाके में पुरअमन तरीके से रह रहे थे ना, अभी दंगे शुरू हो रहे हैं और ये आगे भी करवाएंगे। हमें क्या पैगाम देना है कि हम हथियार नहीं उठाएंगे, हम लाठी नहीं उठाएंगे, हम क्या करेंगे भाई, हम पुरअमन तरीके से ऐसी जगह बैठेंगे जहाँ से इनको परेशानी हो, आपको इन्हें परेशान करना पड़ेगा। आपको ये याद रखना होगा कि अगर हमारी भीड़ अनऑर्गेनाइज्ड है तो बीजेपी को या आरएसएस को या इवन कांग्रेस को, क्योंकि कांग्रेस को भी पोलराइजेशन का फायदा होता है, जहाँ 40% मुस्लिम वोट है वहाँ पोलराइजेशन से कांग्रेस को लगेगा कुछ हमें मिल जाएगा। ये बहुत इंपॉर्टेंट बात है। तो कांग्रेस और बीजेपी चाहेंगे दंगे कराना, जैसे यहाँ मुजफ्फरनगर में हुआ, मुजफ्फरनगर में सिर्फ बीजेपी ने थोड़ा ना दंगे करवाए थे, तो ये दोनों पार्टियां चाहेंगी दंगे करवाना। तो दंगों से बचने का हमारे पास एक ही रास्ता है कि हमारे पास कैडर इतना मजबूत हो कि हम कंट्रोल में रख पाए, नहीं तो अनऑर्गेनाइज भीड़ आप दावत दे रहे हैं, कोई भी केस डाल देते हैं, है कि नहीं? हमको बुलाए चोर, है ना, हमको बुलाए चोर, नहीं समझिए। तो हुकूमत से काम लेना, पहली साफ के लड़के रहे अपने, जो पढ़े लिखे हैं, जो वकील है, जो डॉक्टर है, जो इंजीनियर है, उनको मार खानी पड़ेगी। बिल्कुल पढ़े लिखे बच्चे के मार खाए कुछ नहीं होने वाला। आवाम के सामने शील्ड बन के हमें ही खड़ा रहना होगा, पहले हमको मारो फिर पीछे देखना, ठीक है? ये बात याद रखिए, तरीका यही होना चाहिए और कोई तरीका कारगर नहीं होगा और कोई नेता बनने में आए जो आए लाठी। अरे भाई हमने दिल्ली में हाईवे बंद किया, ये तो छोटी चीज है, तो क्या करना है, सोचो ना क्या करना है, रात को बैठना है, सुबह तक तंबू लगा लेना है कि नहीं? रात को बैठिए। अब मैं ये नहीं बोल रहा हूँ ये सड़क, जो सड़क आपको मौजूद लगे, जो सड़क ऐसा हो उसमें खतरात भी होते हैं, खदशात भी होते हैं, जो जैसे पुरानी दिल्ली में, सीलमपुर में, यहाँ कोशिश की गई, कहीं ऐसा है कि आरएसएस की आबादी ज्यादा है, समझिए इस बात को, तो वहाँ ये होता है कि भीड़ आके हमला लड़ाई करवाने लगेगी, कहीं अंदर से गलफिशा की उम्मीद रहती है, आबादियों से फुलवारी में हुआ ना, ऊपर से पथराव होने लगा, तो आबादियों का ख्याल रखना होता है, हमारे लिए कौन सी जगह सिक्योर है, सेफ है, ये ख्याल रखना होता है। लेकिन एक बार ये सारी चीजें जमा हो जाए एक जगह, फिर बैठ जाएगी, उठने की क्या जरूरत है। तो देखिए अब 10 दिन हो चुके हैं, 10 दिन से हम यहाँ सड़क पर बैठे हैं, है ना? तो याद रखिए कि अब उनका नुकसान बढ़ रहा है। बात सुन लीजिए, नुकसान जो बढ़ेगा तो आपके इम्तिहानात भी बढ़ेंगे, आपको और इम्तिहानों से गुजरना पड़ेगा, आपको भड़काने आएंगे, अफरा तफरी करवाने आएंगे, दंगा करवाने आएंगे, आपको पत्थर नहीं उठाना है।
ये बस याद रख लीजिए, अगर कोई गड़बड़ी कर रहा है उसको पकड़ के कोने में करेंगे, उसका हिसाब पुलिस करेगी। समझ रहे? हमारी जिम्मेदारी नहीं है, हम जो हमारे बीच में गड़बड़ी फैला रहा है उसको कोने में करेंगे, मारेंगे नहीं। समझ लीजिए, इस बात का ख्याल रखिएगा। ये सारे जिम्मेदार जो हमारे यहाँ खड़े हैं, इस बात का जिम्मेदारी है कि हम मारेंगे नहीं, हम कोने में ले जाएंगे, उठा के पुलिस के हवाले करेंगे कि भाई ये गंदगी फैला रहा है, हम तो 10 दिन से बैठे हैं यहाँ, हमने तो इसको अपना घर बना लिया है, हम यहाँ कुछ गलत नहीं करने वाले। एक बात ये
Yes, no.
I will read the bad part. I will read the bad part.
So I was at page number 115 मतलब। इसके पहले तो मैं यहाँ दिसंबर 10 से 11 को भी आया था, और उसके बाद मैंने उस दिन भी यही बात रखी थी कि हमें सड़कों को जाम करना होगा, कि उससे पहले जो मैंने उस दिन भी बात रखी थी। एक है कि सेंसिटाइजेशन, अवेयरनेस, व्हाटएवर, और दूसरा है प्लान ऑफ एक्शन। प्लान ऑफ एक्शन किसी के पास नहीं है। हमें लेकिन प्लान ऑफ एक्शन भी पैरेलल में होना चाहिए कि अगर हमारे पास क्रिटिकल मास जमा हो चुका है लोगों का, तो उनसे क्या किया जाए, क्या करवाया जाए, क्या कुछ कर सकते हैं। अगर हमारे पास जामिया में 10,000 जवान लड़के हैं तो वो क्या कर सकते हैं, ये होना है प्लान ऑफ एक्शन। शहर को सेंसिटाइज करने की हैसियत रखते हैं, तो ये चीज़ है। तो हम लोग 5 दिसंबर से लेकर के 13 को जामिया के जुम्मे वाले प्रोटेस्ट तक चक्का जाम हर जगह दिल्ली चिल्लाते हुए घूम रहे थे। कल सोमवार है, कल तक बैठे ताकि ट्रैफिक जाम हो। फ्राइडे नाइट को तो हल्का फुल्का वायलेंस हुआ था, मेरा भी चश्मा टूटा था। जैसे ही हमने बस जली थी ना शाम को 6 बजे के बाद, तो जैसे ही हमने वहां रोड खाली की होगी, 9 बजे के आसपास ये आदमी आया और इन्होंने पत्थर चलवाना शुरू कर दिया। सुबह तक जब पुलिस चली गई, लड़कों ने दोबारा रोड ब्लॉक कर दिया खुद से 3-4 बजे, और हम लोगों को बुलाया कि आए। अव्वल तो ये, अब हमें दिल्ली क्यों बंद करना है? लेकिन हमें दिल्ली बंद इसलिए करना है कि आवाम को इनकन्वीनियंस हो, ये बहुत है। हम अचीव किए अपना गोल। 20-25 दिन मेहनत करके जब नोएडा से दिल्ली आने वाले लोग कम से कम 3 घंटा लेट होते हैं, तो ये अचीवमेंट है। अगर एक और रोड बंद हो जाए तो 6 घंटे लगेंगे। अगर एक और रोड बंद हो जाए तो दिल्ली में पानी बंद हो जाए। तो ये बहुत जरूरी बात है, ये हमें करना होगा। अगर हम नहीं करेंगे तो हम कहीं नहीं जा सकते। यहाँ हाईवे ब्लॉक्ड है, बाकी कहीं हाईवे ब्लॉक नहीं हुआ है, बाकी कहीं 1 महीने से रोड बंद नहीं। ये मैं पहले भी शायद अर्ज कर चुका हूँ कि 5 लाख लोग हमारे पास हों ऑर्गेनाइज्ड, तो हम हिंदुस्तान और नॉर्थ ईस्ट को परमानेंटली कट कर सकते हैं। परमानेंटली तो नहीं तो कम से कम 1-आध महीने के लिए तो कट कर ही सकते हैं। मतलब इतना मवाद डालो पटरियों पर, रोड पर, तो उनको हटाने में महीने लगे, है कि नहीं? जाएं एयरफोर्स से असम को काटना हमारी जिम्मेदारी है, और असम और इंडिया कटकर अलग हो जाए तभी ये हमारी बात सुनेंगे। अगर हमें असम की मदद करनी है तो हमें असम का रास्ता बंद करना होगा फौज के लिए, समझ रहे हैं, फौज के लिए। और जितने भी जो भी सप्लाईज यहाँ से जा रहे हैं बंद करो, और वो बंद कर सकते हैं क्योंकि चिकन नेक मुसलमानों का है, जो वो इलाका है वो मुस्लिम अक्सरियत है।
Nothing whatsoever in Assam.
Single person.
Speech is in Aligarh. Prosecution is in Aligarh. Bail granted in Aligarh. Speech is again prosecuted in Delhi. Taken into custody in Delhi. 4.5 years in Delhi for this speech. Now they say the speech has led to conspiracy. Because that basic is under 120A, it defines conspiracy. I don't have to place that.
So are they saying, is the prosecution saying, this speech was subsequently circulated in Delhi through that WhatsApp group or whatever it is, which instigated the Delhi riots?
No, they're saying that we all conspired together, the petitioners before your lordships, and pursuant. The role ascribed is different to each one of them. There are some who are members of a WhatsApp group where some chats are taking place about organizing something. There are some who were
You were
there.
arrested on what date?
I'm arrested on 28th of January. Riots happened between 22nd to 24th February. Then there are some who actually are present in some physical meetings, subsequent thereto, subsequent. The role to me, my lords, is only of these speeches. Now, take it whichever may, my lords, they may say that yes, these speeches led to the riots. I would have been prosecuted for those riots, my lords. And 750 FIRs. Not 1, 2, 5, 7, 750 riots FIR. I couldn't have been prosecuted for those FIRs because I am not there physically. I am not there in touch with anyone else on any WhatsApp group, meeting, etc. I have nothing, they have no material. So the only thing that is placed before your lordships are these inflammatory speeches, if I can term it that way, inflammatory speeches. But we come back to that, my lords. Is a speech by itself, my lords, conspiratorial in nature? Does it? And it's not a speech which is only one way. I have shown to your lordships, he gives a call for non-violence. He says, you take the beating, don't attack. You take the beating, don't do it. Don't do anything, just take the beating. That's what he's saying. Riot cases which actually took place pursuant to those conspiracy, section 15 is not invoked. So, how does conspiracy alone to cause riots in Delhi, my lords, invite section 15? Only for the conspiracy part.
You had a Facebook account?
I had a Facebook. I read that, my Facebook account to your lordship.
So these are all pasted in your Facebook account?
Yes, I read what was pasted. They themselves have said so. I read that. The first part that I read was the Facebook. I am not there. In fact, they say that it failed. I showed from the counter affidavit, my lords, that preparation page 35 onwards, I am not there. Page 33. It stops at 33. They say in the counter affidavit that it has failed. After that comes that group, WhatsApp group, etc., DPSG group, which I am not there. So my role is that you organize sit-in in Shaheen Bagh and Jamia. After that, please stop it. After that, you organize it in Jamia and Shaheen Bagh, and they could not mobilize enough, etc. It failed. Then it moved to the next phase. When it moves to the next phase, after having failed, my lords, I'm not there in any manner, not in touch by phone call, WhatsApp group, or any other manner. I'm not even in Delhi. I'm arrested from somewhere else. I'm arrested and in custody. Now, it should be, my lords, that the offense, if it is conspiracy to commit an offense, it should be that offense or some other of the lesser offense that is committed. Suppose I want to commit murder of somebody, murder is not committed, grievous hurt is committed. But there has to be some outcome of which conspiracy, which part of the speech says that commit on between 22nd or 24th, commit this particular act, illegal act. That's the definition of conspiracy, my lords. And today, at the end of the day, my lords, what we are, all of us on our side, and I also, my lords, if 6 years in custody as an under trial, having suffered long incarceration, having suffered multiple prosecutions, in a case for conspiracy, main trials of which are still going on, as far as the 750 trials are concerned, they will take their own time. Given the voluminous nature, my lords, the nature that there is I'm only asking for bail, my lords, at the end of the, and your lordships may only consider that if I am to be released on bail, whichever terms, conditions your lordships are pleased to impose upon me, I am of course duty bound to be under those terms and conditions. But my lords, I have, as a citizen of this country, and I make a prayer to your lordships, my lords, that almost 6 years of incarceration is a long period for somebody to be as an under trial. As far as, given that the trial will take a long time.
Oh.
Because in the end that I'm unilingual, but the two lines of a poet, my lords, if your lordships permit me to say it in a non-English manner, my lords. There are two famous lines of hope by Faiz Ahmad Faiz, my lords. When he was in custody under the brutal regime in Pakistan, he says, Dil na umeed to nahi, naakaam hi to hai. The heart is not without hope. It is just unsuccessful. Lambi hai gham ki sham, magar sham hi to hai. Long is the night of sorrow. It is only but a night. That too shall pass. I'm humbly praying, Lord, that your lordships may be pleased to enlarge the petitioner on bail, Lord, on such terms and conditions as your lordships. I'm obliged to your lordships.
Wait, please, Lordship, let's see.
It's
item 2.4, Shifaur Rahman. I'll be very, very brief. I can afford to be brief, my lords, because there is very little against me. My lords, I have a short note if I do.
What's your name?
Shifaur Rahman. My lords, I am the president of the Alumni Association of Jamia Millia. Male or female? Shifaur Rahman, male. Shifa actually in the language, in Urdu language means remedy. It means something that you take, something you take to heal. Here he is seeking a remedy for himself. Give me the judgment. Yes. Manoj, may I just begin very, very briefly with one judgment? Manoj, there is a lot of talk about conspiracy. Your lordships have held on conspiracy at various times. This was a good judgment, Manoj. There's two paragraphs I will show from this judgment. This is Umar Khalid versus State of West Bengal. Bench of 3 honorable judges, Manoj, 2002-7 SCC. Manoj, if your lordships will turn quickly to paragraph 18.
The 18.
Paragraph 18. Just quickly, two paragraphs that I will show. Paragraph 18, your lordship will find that at page 352. The middle of that, Dean Mullets. I may just read it for your lordships. Therefore, the essence of criminal conspiracy is an agreement to do an illegal act, and such an agreement can be proved either by direct evidence or by circumstantial evidence or by both. And it is a matter of common experience. The direct evidence to prove conspiracy is rarely available. Therefore, the circumstances proved before, during, and after the occurrence have to be considered to decide about the complicity of the accused. Then paragraph 21 just amplifies this. Privacy and secrecy are more characteristics of a conspiracy than of a loud discussion in an elevated place open to public view. Direct evidence in proof of a conspiracy is seldom available. Offense of conspiracy can be proved by either direct or circumstantial evidence, etc. And finally, Mullat's paragraph 23. As noted above, the essential ingredient of the offense of criminal conspiracy is the agreement. Paragraph 23, Mullat, at page 354.
Yes.
As noted above, the essential ingredient of the offense of criminal conspiracy is the agreement to commit an offense. In a case where the agreement is for accomplishment of an act which by itself constitutes an offense, then in that event, no overt act is necessary to be proved by the prosecution, because in such a situation, criminal conspiracy is established by proving such an agreement. Where the conspiracy alleged is with regard to commission of a serious crime, the nature of as contemplated in section 120B, read with the provisions in subsection 2 of section 120A, then in the event, mere proof of an agreement between the accused for commission of such a crime alone is enough to bring about conviction under section 120B, and the proof of any overt act by the accused or any one of them would not be necessary. The provisions in such situation do not require that each and every person who is a party to the conspiracy must do some overt act towards the fulfillment of the object of conspiracy. The essence and ingredient being an agreement between the conspirators to commit the crime. And if these requirements and ingredients are established, the act would fall within the trappings of the provisions contained in section 120B. Well, my argument here is, your lordships have repeatedly held that direct evidence of conspiracy is not possible. Therefore, from the events that happen, your lordships extrapolate whether there was a conspiracy. It reflects circumstantial evidence. It reflects that there was an agreement because direct evidence of agreement is not available. But to assume that there is an agreement and thereby include everyone in it. So even if somebody does not do an overt act, if there is a conspiracy, he gets included. But when you are looking for evidence of overt acts and there is no overt act, to say, well, there's a conspiracy, therefore the need for an overt act is not necessary. That is the caution, my lords, that I'm urging your lordships would want to consider, that to what extent should there be sufficient evidence of a conspiracy in order to take many acts in the ambit of the conspiracy, including acts that do not have an overt act at all. Now, my lords, in light of this, if your lordships will be kind enough to take up my petition, there are, in the entire judgment, my lords, I have only referenced in 3 pages. Very quickly, I will show those to your lordships. This is, it begins at page 117 of the judgment, the impugned judgment. Analysis and findings at paragraph 281.
Page?
At page 117, paragraph 281 of the impugned judgment. Below, your lordship see the analysis and findings begin at page 117 and at page 118 at paragraph 284. As per the learned SPP, the money so received, there's some money received by the petitioner here, was to be used to aid riots and to support their fight against CAA and NRC, so much so that as per prosecution, appellant Shifaur Rahman, that's me, had also generated fake bills of expenses to adjust money used in furtherance of the alleged conspiracy. In addition, appellant Meeran Haider, that's somebody else, that doesn't concern me. Then, my lords, at page 2, at paragraph 285 at the bottom of that page, in our view, the possibility of misuse of position by the appellant Shifaur Rahman being president of Ajmi could not be ruled out at this stage, more so when certain bills were allegedly recovered by the prosecution from Ajmi's office. It is further alleged that the said organization had received a total amount of 7 to 8 lakhs in cash. The appellants are stated to have been in charge of more than 8 protest sites in Delhi NCR. So, my lords, the worst allegation against me is 8 lakhs, the worst allegation, no recovery, no evidence that 8 lakhs was transferred, no recovery, no tracing of that money of 8 lakhs, but an allegation, a bland allegation of 8 lakhs, saying that this money in any case was to be used for looking after the protest sites. A protest site being supported is not illegal, is something that I would submit to your lordships clearly, because a protest is part, as your lordships have held, of part of democracy. But the protest must be peaceful. It cannot be any form of violence could not be used. Now, there is no FIR against the petitioner, my lords, at all anywhere in Delhi, including in Jamia. In the Jamia event, there was violence. Of course, the allegation is that the police barged into the university, there was a reaction, and in response, the students reacted as well. But even in Jamia, where this gentleman, this petitioner, is part of the organization of the former students, even in the Jamia case, there is no FIR against this person. So nothing against, only saying that he could at best be said to have used 8 lakhs, even though 8 lakhs is not proved anywhere. Your Lordship will then see at page 119, various things are mentioned here. And then at page 120, how summarily the issue of parity is dismissed. I have said that I am for sure, my case is stronger than the case of those persons who've been granted bail, because even where they were involved, to the extent they were involved, I have not been involved. I'm not part of the WhatsApp group. I don't have any single FIR against me. Then paragraph 292, your Lordship will see. On the plea of parity is raised by the appellants, we are of the view that the position and role of the present appellants in the alleged conspiracy is placed differently than the co-accused persons in the entire sequence of events, allegedly being one of the fundraisers in the conspiracy that would warrant the benefit of parity to be extended to them. Further, we have dilated on the plea of parity with the co-accused granted bail by this court in foregoing paragraphs of this judgment in extenso, and the same may not be. Viewing thus the plea of parity is not made out in our considered opinion. So, my Lord just summarily says parity is not made out for a person against whom there is no FIR, for a person who is not accused of violence, for a person who has made no speeches that anybody has accused him of being inflammatory and so on. So your Lordship will just briefly look at the short rebuttal note that I have given to your Lordship.
Yes.
Well, I put my Delhi address there. At the top, your Lordships had indicated that we should give our Delhi address. Petitioner's background and conduct at the trial. In the second paragraph itself, we've indicated that we are not responsible at any stage and delay as far as the trial was concerned. Your Lordships will see that we concluded arguments at the first opportunity on the charge in a single day, of 11/7/2025. Your Lordship will find this in the counted page 25-26. And the order dated 1st of August 2025 will indicate this. There was no delay at any stage. We didn't delay the matter on section 207 at no stage. Your Lordship will then see I'm a respectable citizen. I have no previous background of antecedents of crime, but I've admitted that I had sympathy for the protest movement against CAA and NRC, and I was in the region of Jamia Millia, neither there or at the Okhla protest, which was the protest of Shaheen Bagh, was I accused of having done anything which would be considered to be unlawful in any manner. Then, my lords, your Lordship will see on the second paragraph on page 2 of this note, there's an alleged meeting of the 22nd of February, which mentions Ajmi office bearers, but does not name the petitioner. Even to that extent that somebody would name me as being party at any proceedings, at any meeting where I would have said anything would be in the nature of conspiracy. My lords, this relates to witness bond, the statement that was read to your Lordship. My lords, so if your Lordship will see, the next paragraph is my argument about the issue of conspiracy. During the arguments, the other side said that Section 10 of the Evidence Act would be utilized to involve anybody in the acts of those persons who are part of the conspiracy, that not everybody had to do everything that was part of the conspiracy, but once the conspiracy is established, then of course it sticks to you. But it can't be an assumption. I have argued that your Lordships would be would kindly consider two dimensions. One, mens rea cannot be thrown out completely when there is a conspiracy. Mens rea must be there. In fact, the meeting of minds means that mens rea must be there. One is mens rea, and the other one, of course, my lord, is causation. It's very important that they should be able to show that causation is, as your lordships have held in Sushil Ansal's case, Sushil Ansal is CBI, that causa causas is important, that causa sine qua non is not sufficient. So there has to be a direct causation and linkages. Your lordships will see at page 4, your lordship will see.
Actually, arguing afresh,
Maloj, I'm putting this in a perspective, because what has been argued, Maloj, may I just say so? Your lordships have heard in great detail to what extent is a person involved, not involved, what have they said, what is the implications, what the impact. I'm simply saying that I have said nothing, I have done nothing, except to the extent that I concede that there was money collection, very marginal money. In fact, I've conceded only that 1 lakh rupees was collected and used for what? Even the allegation against me is that it was used for giving it out to the protesters so that they could cover themselves in very bad weather. They could have some cover over their heads, etc. For that and for food and tea and so on and so forth. Well, that's something that in a protest we all have done and gone. Well, I have taken the liberty to place at page 5 the history of the protests in India and how protests are part of the vibrant Indian democracy. Of course, there would be cases where there is an infraction of the law and people are answerable for infraction of the law. And I would be too if there was an FIR against me alleging that I had done anything wrong. So, my lords, I'm only putting it in perspective because your lordships have given so much time. Conspiracy where there are people involved. Well, when there was a protest movement, there must have been many people in different parts of the country and certainly different parts of Delhi who responded in a manner which was passionate or a manner which was from their point of view very significant and important. But to assume that everybody who responded anywhere and did anything at all was itself part of a conspiracy, my lord, I believe that would be making it a very dangerous ground for making people culpable for something where the law does not.
Yes, Mahatma Gandhi also.
Well, Mahatma Gandhi, your lordships know that in civil disobedience, well, where the line is to be drawn, we have to be careful. But civil disobedience does mean defiance of a law. Defiance of a law not to do violence, but defiance of some law and being prepared to take the punishment for defiance.
I was just seeing whether they encapsulated Jallianwala Bagh. It was peaceful.
Well, it was peaceful. You're right, my lords. It was peaceful, and the reaction against that.
General Dyer.
General Dyer. General Dyer, and your lordships know what that did to history. Well, there is one last point that I would just want your lordships to consider. There is the concept of conspiracy theory. We often use this in common parlance, conspiracy theory. I have a chapter, if your lordships will find it suitable, your chapter will read on page 3. On page 3, just above the material is not inculpatory, I've written something about conspiracy theory. Conspiracy theory is where you leap over all the requirements of the law and you just give the dog a bad name and hang the dog. Well, that's something that should be avoided. And then, my lords, there are all these issues about conviction rates and so on, but I do concern, I'm concerned, A for Sharai, every argument that anyone can use in this is applicable to me, even in a stronger manner. I'm grateful, my lords, for the time given.
Would I beg to appear in item 2.2? For Meeran Haider.
1 second. Meeran Haider.
Please. Now, I will request towards I had given at the time of the opening is 4-page note, 5-page note. If your lordship just have that.
One second. Yes. Given by Devina Seda.
I'm most of that. I have another copy. One more copy.
It's your duties on trade which is given, which I think what item, at what time, which serial number. I have got it.
I know. In fact, your lordships had also been kind enough to make some notice because there were some additional points. But I'll give another copy. In my opening, the tenor of my submissions was the following. That overall bail considerations because I had placed, and in order to look at the issue of merits, I had placed salient allegations against me in the form of a table with brief responses in order to indicate that I crossed the threshold which is prescribed under the law for grant of bail, even if merits are to be considered at the present stage. I will begin by first taking your lordships just to that, because really today in rebuttal is confining itself to two things. And that's the one question which your lordships have put to counsel before me and which stares at me in the face as delay attributable to all of us or any of us. And if it is so, then this repetition or harping on the 6 years that we are doing, is that a further waste of your lordship's time? It's something which I can actually invoke and seek the indulgence of this court to grant me. So delay is one and parity is the other. Those are the two aspects which will indicate that what the state is today submitting before your lordships, whether that needs to be gone into for the purpose of deciding these bail applications on the specific merits and nuances of each of our cases. So please come. As I said, to satisfy the judicial conscience of this court, I had in paragraph 2 made a table at page 3 of my note. And I had indicated this is the allegation in the third column.
Public allegation and response.
I am most obliged. For example, please come to point number 3. I am so sorry. Point number 5. There were conspiratorial meetings, physical manifestation of a conspiracy in togetherness, where according to them, people were sitting together and hatching these plots. The allegation was that I had attended meetings which were planned in 2019. Please see the response, item 5. 2 conspiratorial meetings were allegedly held in December 2019, being 8th of December at Jankura and on 13th of December at Jamia, which are being attributed to the petitioner. The allegation is ex facie false, as the petitioner was not even in Delhi on 4th December to 14th December due to the death of his mother. In fact, the state's false case on attendance in Jankura meeting is evident from the photograph where the petitioner is not seen. Equally, he is not seen in other meetings. Because I point this out today to remind your lordships about one thing. Your lordships will recall, please have page 54 of the counter affidavit that they had filed. Paragraph 95.
Again on 15/12/2019.
Or 8/12/2019. It's paragraph 95 of the common counter, page number 54.
95.
Yes.
On 8/12/2019.
On 8/12. on 8/12/2019, a meeting at Janpura, Bhogal, New Delhi was organized by so and so, attended by A, B, C, D, E. Please see my name there.
Meeran Haider,
I'm most obliged, and others. It was decided in this meeting to execute the earlier alleged conspiracy of Chakkajam to engineer riots. The same is substantiated from the evidence on record as follows. Please turn over the page. And there's a photograph there. This your lordships had seen. And please note, I am not in that photograph. The entire set of evidence below this does not have anything to do with me. And the reason for that was, and I had pointed out, that in the charge sheet, which has been placed on record, only one page of which is relevant. Page 2020. For facility, I am handing over that page of that charge sheet which they have filed before your lordships.
Where is it?
They had filed the charge sheet in a pen drive before your lordships. And what I'm handing over is that one page 2020 of that charge sheet. Where the allegation pertaining to this very meeting is made at the foot of page 2020. On 8/12, a meeting was held at the. Everything else is the same, word for word, except my name. The photograph is overleaf. I argued this was in the opening to demonstrate that when such large charge sheets are filed and witnesses are there and documents are there, there are errors which sometimes go to the root of the matter and sometimes need to be addressed and analyzed by a trial court in the course of hearing. So when your lordships are looking at these materials, your lordships are not necessarily doing it with a view to determine guilt or otherwise. But your lordships are looking at it from the point of view of, does the accused have something to say? Is there a legal argument? Is there a factual argument? Is there a submission that is available to this accused, which the learned trial court tomorrow will examine and determine one way or the other? And in that interregnum, should he be kept in custody or not? That is my humble submission, is the formulation. Today, in answer, I ask myself what the state said to all of this, nothing. So I have now spent 6 years in custody almost on the strength of an allegation of being involved and participating in 2 specific meetings where my case is specifically 4th December to 14th December, I am not in the city.
No.
The reason I'm not in the city is because my mother had passed away, those train tickets are available, everything available with them. Now, in this light, let me refocus my attention to the issue of delay. And why is that? Submission of the state, the biggest bogey in this case. The fact that there is a delay is a admitted position on either side. They attribute it to me. I attribute it either to them or to systemic failure, either which way. But the fact that for 6 years we are in custody, awaiting the onset of trial is an admitted position. Now, in order to determine the assessment of delay, when your lordships are obviously looking at it in a special leave petition, the first thing that would be available to the court would be, how has the High Court analyzed this? This argument, if it is of substance, must have been raised by the state before the Honorable High Court. Please come to the impugned judgment. Page 25, paragraph 29.
Proceeding further.
I am obliged. Proceeding further, we would like to note that there has been much deliberation on the point of delay in trial and the period of custody suffered by an accused awaiting trial even in offences under special statutes. It has been held by the Supreme Court that though the rigorous provisions laid down by the special statutes place an embargo on the courts, ordinarily leading to rejection of bail to an accused, the same does not denude the discretion of constitutional courts to grant bail. And then, my lords, certain case law is cited, which has also been cited before your lordships in the form of Najib, Sheikh Javed Iqbal, etc. Please come to paragraph 33, page 28. From a perusal of the aforementioned extracts, it emerges that the constitutional courts are well within their powers to grant bail to an under trial who has suffered long periods of incarceration pending trial, thereby setting him at liberty. The courts are also to secure the right to a speedy trial of an accused, flowing from Article 21 of the Constitution of India. However, the grant of bail on the sole ground of long incarceration and delay in trial is not a universally applicable rule in all cases. The discretion to grant or deny bail rests with the Constitutional Court, depending on the peculiar facts and circumstances of each case. The Supreme Court in Sheikh Javed Iqbal Supra also noted that in the given facts of a particular case, a Constitutional Court may decline to grant bail. Further, the interest and safety of society at large, apart from victims and their families, is also a factor to be considered. Please come now to page 71. Paragraph 147. I am indicating these paragraphs as the sole repository of the argument on delay by either side. Page 71, para 147. As far as the third limb of submissions. As far as the third limb of submission, I'm so sorry.
Yeah.
As far as the third limb of submissions on delay in trial and prolonged incarceration is concerned, we have already discussed the position of law in this issue in detail here and before in the preceding paragraphs. Needless to say, the prosecution has strongly alleged about the magnitude and involvement of numerous conspirators, individuals, and organizations who are stated to have mobilized thousands of people in protest with the national capital of India, resulting in 54 deaths, injuries caused to numerous persons, and destruction of movable and immovable public and private properties. The investigating agency has made earnest efforts to unearth the alleged deep-rooted conspiracy, as is evident from the undisputed fact that the charge sheet runs into more than 3,000 pages with an additional 30,000 pages of electronic evidence. The state carried out a detailed investigation which led to the arrest of several individuals and the filing of 4 supplementary charge sheets with multiple accused persons charge sheeted and as many as 58 witnesses, including the protected witnesses whose statements under 164 CRPC were also recorded before the learned magistrate. In such a background, the pace of the trial will progress naturally. A hurried trial will also be detrimental to the rights of both the appellants and the state. The parties have informed this court that the trial is currently at the stage of hearing the arguments on framing of charges. Thus, it indicates that the case is progressing. This, Lords, in my humble submission, the case of the state was not that these 5 or 6 people who today are seeking bail are the reasons responsible for actually delaying the process. Their case was before the Honorable High Court, sir, the case is too big. The case is too involved. It requires detailed and deep-rooted investigation. I am doing a great job of it. And because it is so big, it will take time. Have patience. 2nd September 2025 is the date of this judgment. It is nobody's case that from 2nd of September 25 till 2nd of December 25 or 8th or 9th as today we stand, that in the last 3 months delay has happened, which is attributable to these 6. The fact that this argument is not raised, the fact that the material pertaining to this argument is not put before the court, the fact that the court does not get into these issues, the entire issue on delay is on the other side. That argument, Lords, in my humble submission, being raised before your lordships today for the first time is a bogey. Now please see, please leave this aside. But let's consider 4 dates in order to determine what is the delay. So what do they invoke for delay? 4 dates your lordships may note. 6th of March 2020. Hold on. Sixth of March 2020 is when the FIR was registered.
and 59 of 20.
I'm obliged. I'm obliged. Multiple charge sheets came to be filed, last of which was on 7th of June 2023. That is a period of more than 3 years. The first time the prosecution / the court put to the accused persons, and I'll treat them as an en bloc. Let us start arguments on charge, was in October of 2023. That your lordships may change that to September of 2023, evident from page 20 of the common counter.
Page 20, is it?
Page 20 of the common counter will indicate that on 18th of September 23, the accused persons submitted that the arguments on charge should be deferred because the prosecution must first take a stand on whether the investigation is complete or not. The entire argument of delay today before your lordships is, look here, these accused persons, they refused to argue on charge and they were demanding that we should tell them whether our investigation is over or not. It was in my humble submission, as per the law laid down by this court and as per our understanding, there is a sequential process. Investigation must, at least in the moment, conclude. You always have the power to do further investigation if fresh material comes to your notice. There's no denying that. But at some point in time, there must be a quietus to your investigation for a court then to apply mine on the material as it is. So what did the accused say in September of 23? Mr. Prosecutor, please tell the court whether your investigation is over or not. If it is, we will commence arguments on charge. If it is not, please await your investigation to be over. 18th of September 23, when the learned judge asked them, yes, all right, tell us, is your investigation over? They answered that question in the affirmative. Yes, investigation is over in September of 2024. 1 year. This 1 year is what they attribute as a delay to us. So I have two submissions. Number one, that delay does not lie at my door. Because if I am insisting on rights, if I'm insisting on due process of law, if I'm insisting that the investigation become over and it be declared so before I am called upon to argue on charge, I am doing nothing wrong. And that delay cannot be at my door. But B, assume it is. Assume that I, in my overzealousness, decided to put the prosecution to notice. How dare I ask them a question? And I should have gone ahead and argued my charge. When did arguments on charge actually commence? 1st of October 2024. So let us now exclude this period of 1 year. From September 23, when you called upon me to argue charge, till October 24, 5th September 24, when charge is actually commenced, let's exclude that 1 year. So let us, all of us on the defense side, on the accused side, not harp on 6 years. But surely, may I be allowed to harp on 5 years? Is 5 years conscionable? The question of delay this is the second reason why it is a bone. That the period of September 23 to September 24 is actually on their doorstep, is being today palmed off to mine. My submission is it does not lie at my doorstep, but even if it does, we as a collective are said to be responsible for 1 year of delay because prior to September of 23, June 23 is your last report, which also says investigation is pending. It's not as if the June 23 report indicated investigation, no. The last report filed by the prosecution before the learned trial court says in those words, my investigation is pending. Now let's come to me, because surely there's a conspiracy to commit riots, there's a conspiracy now to delay. Because all of us are now being banded in the same way to say that there is a delay. Please see the common counter. Two orders are placed, page 217.
Two
217. So, your Lordship will note September 24, the arguments on charge commenced. This is annexure R4 to the common counter, page 217, an order of 1st of August 25. Now, what happens in this ordering, that various accused persons are asked by the court, when will you argue? So that there is a certain scheduling to it. The learned trial court in all earnestness is saying, I need to plan the calendar and the docket of the court. I need to figure out who's arguing when. So some accused person says, I will do it in 2 weeks. Somebody says 1 month. Somebody says, I don't know. That, your Lordships will find at page 219, the 4th paragraph. On that particular day, when the learned trial court asked me a question, when will you argue, Mr. Haider? He responded at para 4 saying, accused Meeran submits. He has not spoken with his counsel, so and so and so and so, and he has no knowledge as to when his counsels will address arguments. That was his position as on that date. The matter was at 220. I can understand if this statement led to 6 months delay. At 220, the matter goes from 1st of August to 4th of August. All right, you don't know on the 1st. You tell me on the 4th. On 5th of August, page 221, the next page, arguments continue on behalf of some accused or the other and have been continuing. So we are now saying that a person not being aware exactly when my counsel will be aware, whether it is going to be in 2 days' time or in 2 weeks' time, and I was not able to answer that in person to the learned trial court, and that resulted in deferment from 1st of August to 4th of August. Delay is a bogey. My submission for your Lordship's kind consideration is that when one looks at delay, it is not, and I say this with utmost respect, there can never be one reason or cause for delay. In a matter where 5 years have passed, there can never be one reason or one cause for delay. The question again comes down to, from the Najib perspective, is this. The fact that you have spent 5 years, 8 months in actual custody for an offense for which you yet have to be charged, for which trial has to commence, and absolutely the court is right. 3,000 pages of just the opinion, 30,000 pages otherwise, electronic data, multiple witnesses. Is this a trial that will finish in a framework of time that will satisfy the conscience of a court to say, no, this is reasonable? Because every subsequent day to day is the cherry on top and then the cherry on. Because as far as I am concerned, the second aspect was parity. What was told to your Lordships was that the judgment of the Honorable High Court, A, did not consider the merits of those 3 individuals.
Next subsequent order sheet of the trial court also shows that nobody has come forward to argue.
No, I'm so sorry. These have 222 foot. 222 foot of the page. Shri Adit Pujari, learned counsel for accused persons so and so, concluded his arguments, seeking liberty to address arguments afresh if requirement arises on disposal of his petition. That's a separate issue. But he argued and concluded his submissions. And then after that, the schedule was fixed for the others. There will all, as I said,
26. Today, nobody has come forward to address arguments as the point of charge. 227.
That's right.
228. Today, nobody has come forward.
In a case where there are multiple accused, where
nobody has come forward. Again, on page 230.
I bowed on that. And what is happening is, with which one? 12th of August.
233. Today, learned counsel submits the matter is already fixed for him. But at that time, he may be stuck in another matter in some other court. In argument on his behalf, we have now.
Because what these order sheets indicate is that where there are multiple counsel, there is a difficulty of a particular person or the other on that particular day. There's a schedule which is fixed. As far as I'm concerned, the date for my arguing on charge, not yet fixed. I have to argue for one day. Whenever that day will come, 8 people have already argued. The others are remaining to be argued. And because I in fact have a timeline of the arguments on charge, there are certain dates on which your lordships are right that no arguments have been heard. There are about 7 or 8 of such instances. There are multiple instances, 85 dates, where arguments have been addressed. So it is not a situation where there is the accused is not at all cooperating with the process, but definitely not a situation where I am responsible for that. The reason I showed that 1st of August was because my submission is recorded there saying I don't know when I will argue on the issue of parity. The first submission made by the state before your lordships was that the High Court judgment granting bail to those 3 individuals did not deal with merits of their case. That is factually wrong. The relevant paragraphs are noted. I'll put that in a note if I have to, and otherwise I can. So paragraph 58 in Asif's case, para 37, 46 to 47 in Devangana's case, and 26, 34 to 35 in Natasha's case. Their merits were considered by the Honorable High Court. In fact, when the state came to the Honorable Supreme Court, it said, look here, detailed consideration on merits have been made, on the law has been made, and which ought not to have been done at the stage of bail. It is for that reason, while issuing notice, your lordship said not to be treated as a precedent. But that's not the final order. Your lordships have seen the order. Can we just show that order on parity? Supreme Court.
The P4.
Annexure P4 to my petition. This is the final order passed by this court, not interfering with the bail granted to those 3 individuals.
1 second. Page number?
Page numbers will be 310, annexure P4.
P4. Has been to order dated 2/5/23.
I am obliged. May I place 311, which is where the order begins. The impugned order is an extremely elaborate order of bail interpreting various provisions of the UAPA Act. In our view, the only issue which is required to be examined in such matters is whether in the factual scenario an accused is entitled to bail or not. It is this argument which persuaded us, while issuing notice on 18th of June 21, to observe that the impugned judgment cannot be treated as a precedent and may not be relied upon by any of the parties in any other proceedings. The idea was to protect the state against the use of the judgment on enunciation of the law or the interpretation of the provisions of the UAPA Act in a bail matter. The respondents have been on bail for almost 2 years. We see no purpose in keeping these matters alive. We may notice that one of the co-accused has filed an application seeking in a way to interpret our interim directions of 18th of June 21 and submitting that the said observations were coming in the way of seeking bail. The applicant is a co-accused. If the co-accused is entitled to a plea on parity, that is for him to make and the court to consider. We want to make it clear at a cost of repetition that the purpose of the interim order of 18th of June was that the that the expounded legal position regarding statutory interpretations in a bail matter should not be utilized in proceedings either of co-accused or of any other person or any other matter. With the aforesaid clarification, the interim directions dated 18th of June are made final directions in the matter. On having noticed the aforesaid, we close the present proceeding. So what was indicated was that the enunciation of law by the Honorable High Court.
In fact, we have argued with Mr. Agarwal. On the last occasion, we have argued. We have noted down. We have highlighted in page number 312, third line, from the words we want to till any other matter.
The reason of saying it again in rebuttal is that the answer of the state today to that argument was that the embargo placed by this honorable court precludes any co-accused person from raising an issue of parity, which in my humble submission is not correct, is contrary to this argument. I will end by saying neither my speeches have been played out, nor has it been read out, nor has any specific act or omission pertaining to me been indicated as to being so overwhelming that denies me the aspect of bail. Those are my sons.
I just had one sentence not really to add. I'll give your lordship a note because I don't think much has to be said in rejoinder on my behalf. And the only thing is what I pointed out that based on the CDR, I'll just give a contradiction charge that the CDR showed me that I was.
Have you given the note or
no, not? I'll just give it. I'll give it to your lordship to him. I was not there at the point, but I'll give over the note. I don't think there's any need to reiterate. It's just to point that out. That CDR just shows I was not there. Later, 1.5 years later, they changed their stand, bring in oral evidence to try and show me there. The CDR shows differently, and neither the High Court or the Trial Court is considered. That's the one sentence I have to say. 2.6 Shadab Ahmed is my thing.
Well, I beg to appear in 2.5. Well, I just need 1 minute, one judgment, no factual rebuttal. Very well.
Because I requested the other side, they are on. 46.
What is this matter?
This bail matter, Manu. The lady is behind the bar since May. Counter is not filed.
So the sent was not available.
Not filed.
Not filed. Counter is not filed.
No, it's been filed, Manu.
We hold the copies, Manu. Lordship set up.
We have verified from the registry, sir. It is not filed.
I'll just check that. Just check it.
You might have given the copy to the other side, but if you don't file it in the registry, what is to be done? It is not even in the defective.
I'll just clarify.
Item 47.
What is that matter about?
My lord, that is a matter of bail, my lord. An old lady behind that is in.
Did not do double murder.
Double murder, the same matter, my lord.
Have it post on I'll just sign.
Or it could be taken up tomorrow at top of the board, my lord. Today because it's their mistake, my lord. Last time also, last week also, I came all the way.
Chance. If you want to take a chance, you take a chance.
Item 47.
Counsel, patience, sir. We are interacting with your brother advocate. You want to butt in and interrupt the court proceedings. This can happen only in Supreme Court.
I apologize on his behalf.
No, not necessary.
But not
when one side is arguing, other side interfering, objecting, all this.
But this is a lament we are hearing very often for some of us who've been here for a few years and we are here to blame.
I don't know whether it's happening in our court or in all courts.
Not, I think this is something which never used to happen earlier, but now we are being reckless. It's our fault. We have to correct ourselves.
No, but I have seen, I have come to Supreme Court many times. I never seen.
It's happening in a number of courts. It should not be happening. But it's our lapse. It's completely a lapse on our part. We have to be patient to let one
because
person.
Luthra, what we were told, our seniors is when your friend is arguing, if you interrupt, it is showing disrespect to the court as well as to your opponent. So never interrupt. This is what we were told by our seniors.
But I will only say this: some of the high courts, we find that our side are a lot more disciplined than sometimes we are here. That's a lapse on our part.
I've seen only 2 high courts.
But I've seen Not barring two, I've seen all of them now.
That's
I
right.
think Manipur is the only one I've not perhaps seen. Not
You're a
Manipur.
globe-trotting.
I've seen Manipur.
I've traveled not a fair bit, so
So,
we need to correct ourselves.
oh. Come on. See, post-plan session, we'll see.